Okay, ladies and gentlemen, welcome back. We still have our four speakers with us for a panel debate, and also I hope the debate will be informed by your questions and comments. But before we turn to the audience, and I must tell you there will be two roving microphones in the room to amplify your questions and comments. Before I do that, let's give Kevin Siggy a chance to respond to what Leslie and Marlies have told us.
Exactly. I think that we should turn very quickly to the audience, who's been extremely patient, and so I would like to hear your comments. Let me say that I thought that the commentaries were really very thoughtful, extremely interesting. They raised a lot of important points, and that some of the disagreements that we might have are based on what I would call the dilemmas we face in world politics with counterfactual reasoning. Now, that seems a pretty complex way to say it. What I'm saying is many of our disagreements might have to do with situations like the situation in cases in Uganda, in Sudan, in Kenya, where Leslie might say, well, I think things in Sudan would be better off today without the International Criminal Court involvement. And I would say, well, you know, I actually think things in Sudan would be worse without the involvement of the International Criminal Court. And we can't resolve that issue because there's only one case, and we can't resolve the different counterfactual. It's a little about the Professor Werner's point about, he suggested that there's a powerful coalition pushing aside alternative ways of dealing with mass atrocity. Okay? Well, I'm not persuaded that's the case. Okay? I don't see evidence that the coalition in favor of individual criminal justice is pushing away other kinds of ways of dealing with atrocity. To the contrary, I would say what we're seeing in our database is that the countries like Argentina that do the most for criminal justice also do more of every other kind of way of dealing with past atrocity. But again, it's a counterfactual argument. We really can't resolve this one because he says, I think that this demand for criminal justice is pushing away other alternatives, and I'm saying, actually, I think the demand for criminal justice is often accompanied by demands for many other ways of addressing. And so I would just suggest before we now open, and I wanted to say that Professor Glacius' remarks with regards to victims, I couldn't agree more. And that is that victims have very complex demands, very changing demands. They often believe that they'll be helped very much by trials, and discover to their dismay that, of course, criminal justice can never return their loved ones to them. So I wanted to thank the three of you for your thoughtful remarks, and I wanted to take time to open to the comments from the audience.
Okay, we might come back to that later on. Let's see where the questions in the room are. Over there, yeah.
Sorry. Hi, my question is maybe a little bit beyond the scope of this debate, but it's about the main movie during the festival, The Act of Killing. I was wondering, it's about the people, the anti-communist movement that killed a lot of people, but they were never punished for it. And I was wondering if it's still possible that they are going to be punished, and if so, would that be important for world politics, for human rights politics? So, is it possible to punish them still, even though it's more than 40 years ago? And what is necessary also to do? So that's my question.
Thank you. Okay, we're going back to Indonesia, 1965. That's not in your database. First of all, the question is it still possible to prosecute these crimes? Secondly, would anyone in the panel, given the situation currently in Indonesia, say, yeah, that would be a great idea? Going back to 1965. Come on, you'll have a mic.
It depends on whether because we're talking about individual criminal accountability here, it depends on whether the accused are alive. And I don't know the case of Indonesia very well, but I have looked at another case, Spain, the case of Spain, where most of the violations happened during the Civil War in the 30s and the 40s. Well, it turns out that no, in Spain they're not alive. And so, specifically, you will not be able to have prosecutions in Spain, individual criminal prosecutions. That doesn't mean that other measures can't be taken. In the Spanish case, exhumation of graves has been very important. In the Korean case, very important truth commissions have taken place about killings that happened 50 years ago. And so I will leave it to others who may know the Indonesian case better to say whether some trials may still be possible.
Maurice, who once did a PhD?
That is a long go. I would not want to go further in speculating than say, expect the unexpected, you never know. And as to the time frame, the Khmer Rouge trials date from crimes that happened more recently, but not very much more recently than the 1965 killings. But the main thing I would emphasize, what Catherine also says, is when you have crimes of that magnitude, 500,000 people killed, and it has been a taboo in Indonesia for such a long time, probably it will not go away. So there will be forms of transitional justice. I think it will come back to Indonesia, but whether that will be in the form of individual prosecutions, I doubt, but I would never say never.
Okay, thank you. There was another question there too, I think. Yeah.
That's difficult. Thank you very much. First of all, I would like to thank you, speakers, for this inspiring symposium on the topic. It's a very important topic that we have to discuss, actually, human rights, prosecutions, changing moral politics. We have talked about the relation between justice and peace and the different mechanisms of a way of implementing the legal systems and social thoughts, like, for example, expressivism and the consequences of prosecution. But I'm here on behalf of the Europe. We're lucky to have brought some international students here from different countries, and we talk about in our situation. We talk about the difference between prevention and prosecution, and not prevention in the way of when you prosecute someone that at that point you're preventing, for example, you get them out, you get the key perpetrators out of the peace negotiations. But I'm talking about prevention in the way of educational systems, political stability, resource allocation. And I think it's important that we think about the priority. Do we want to prioritize prosecution above actually going for these prevention methods in a different way? And I want to ask you how I can prioritize these things and how we can think about that as a students' association, because we will be working on this in the future even more. And I think the prioritization of this is very important. So I would like your opinion on that.
Okay, anyone in particular in the panel? Well, there are all of that ones.
Yes. I would like to ask, sorry, I forgot your name in the middle.
Sorry. Thank you. It's a great question, and sounds like you're doing very important work. It's interesting. I heard a short talk given by the man who is the Democracy and Human Rights Officer at the European Council on Foreign Relations, and he had a very interesting and I think a very good argument that might at some level be relevant to you. And he said, we haven't succeeded. This is how the thinking was going in this program. We in Europe haven't succeeded. And we can think about our future human rights work through a range of mechanisms. One is we can war a battle of ideas. We can wage a battle of ideas. We can just keep saying, you're right, you're wrong, this is what's important. And I don't think that's going to work. And then he said, what I think we should do is we should think about leverage and pressure points and where we can be most effective. And so if you're thinking about prevention, longer term education, all sorts of things, I guess my question would be, choose the places and the spaces and the cases where you think you can be most productive and most effective. It's a long-term game. I'm tremendously supportive of a huge amount of the activity in this arena, but I just think that there are spaces and places and cases where we shouldn't focus the majority of the resources. So it's a sort of longish and a little bit vague answer to your question, but I would say, go for the cases where there's some hint from within that there's an interest and there's a constituency that can be built up to bring all sorts of longer-term preventive mechanisms that will have lasting impact.
Catherine?
I would say, as I said earlier, I don't think it's a zero-sum game, okay? And that I don't think to do better education, you have to prioritize education and not do prosecutions. Let me give you an example. The countries that have incorporated human rights education in their secondary school system, the best job teaching secondary students about it, are countries that have had prosecutions already. Why? Because it's easier for a textbook, a national textbook, to cite what a national court has done, okay, than to cite what an Amnesty International annual report has said about their country. So I was in Argentina, I was amazed how Argentine textbooks have really incorporated their past. And they do it through using material from the trials of the juntas in 1985.
Thank you. Other questions? Yeah? Over here, on the second row. Okay, we trust him with the mic. Okay, there is some authority above me, so I'll figure out who it is. He won't be here next year.
Thank you. My name is Ronnie. I'm here on behalf of the Dutch United Nations Student Association. And I have a couple of questions, but I'll stick with two very short ones to start. The first one is for Catherine. I want to hear more about the role the United States plays in this, of course. It has been alluded to by several speakers. I hate to see time run out before we can discuss it at length. Secondly, the theme, are human rights prosecutors really changing world politics? I was interested in turning that on its head and wondering, how do current trends in geopolitics, and specifically the rise of China, which is also not a signatory, and India becoming very important, is also not a signatory, and maybe different values they bring to the table, how does that influence the prospect of human rights prosecutions in the century to come? Thank you.
Okay, Catherine, big politics here.
I'll maybe I can do the first part, and then turn the second part over to my colleague. In terms of the United States, it's quite clear that the United States is in violation. During the Bush administration, U.S. torture policy was clearly in violation of our international obligations under the Convention Against Torture, which the United States had ratified prior to engaging in torture and had not reserved against universal jurisdiction. It was also against domestic law. The Torture Convention had been instituted a domestic statute. For the time being, it seems unlikely that we're going to see domestic prosecutions in the United States. Nevertheless, the threat of foreign prosecutions using universal jurisdiction has had a very chilling effect on U.S. officials. We know directly that people like Donald Rumsfeld and others are no longer traveling to a number of European countries because there have been cases brought against them. They have not succeeded, but cases in France, in Germany, and in Spain. And then, of course, there is the successful case I mentioned in Italy at the CIA. So I would say, for the time being, the pressure of foreign prosecutions could have a very positive effect on the United States, just the way the pressure of the Pinochet arrest in the United Kingdom had an effect on opening up the possibility of prosecutions in Chile. So I would urge you, as Europeans, to make a bigger effort to move ahead with foreign prosecutions of U.S. officials for violation of the Convention Against Torture.
You might want to say something about
I'm sorry.
I don't care about Burma and China, but first.
I mean, I feel like I have the sense of how it must feel to be in Libya, hoping that that disability challenge is successful. I'd absolutely like to see those people who are responsible for the torture policy held accountable, but I want them held accountable in my own country. Not in Britain, where I reside, definitely not in Britain, where I reside, and not in Brussels and not in The Hague. I'd like them held accountable in the United States before an American audience with people right there present, engaged, because I think it's absolutely essential, and I think that that's not unlike how a lot of people feel. And the effort to sort of move this abroad away from the context of the people who elect, choose, support actively or passively these leaders can actually come to grips with what they are at some level engaged in. I have something to say on the China, but I think I'll do that for you. Okay, go ahead.
But you want to respond?
I just say no country wants to have foreign trials, okay? And no country likes foreign trials. I promise you, every country despises the fact of having their. But unfortunately, countries that decide not to have accountability, like Obama has said, no, we will look forward. We don't want to look back. This is why it's a decentralized but interactive system. Foreign prosecutions are a lever to pressure countries to do what they should do, which is hold domestic prosecutions.
And that would also work in the US?
I'm not sure it would work, but I think it's worth a try.
Let's first go to China and come back to this one.
Okay. Is it on? Yeah. If I may also have on the point of the US, because it's a very interesting point, because it shows kind of the ambiguity, because on the one hand, there is legal debates all around, right? So there is a constant debate in society, and if you look at the example I gave, also if it comes to the very controversial drones program, there is military lawyers everywhere. What is not there is after the fact in a court of law checking the facts and checking the legality. So it is more ambiguous, so that and that of course could eventually could be channeled into domestic prosecutions as well. Just let me respond to one remark that you made about no country wants foreign trials. I think one of the interesting things about the ICC is that for some countries this is very comfortable to have, well, international trials, at least not trials in their own country. This is not just counterfactual, this is actually in the aims of the government, and this is how, for example, the Ugandan government went ahead. So that creates an interesting dynamic where you find the Justice Cascade, if you can call it that, working in politically kind of unexpected ways, because at the beginning of the ICC expected that this would be such a huge deal. Then as to your question about China, I'm not a China expert, so as a layperson, all I can say is that, well, it's not very likely that this will give a big push forward to human rights prosecutions. Not only for China, but what I mentioned, what is likely, but this is speculation, is that, for example, multinational firms active in African countries that have signed up to the Rome Statute, Chinese companies that might be connected to human rights violations, there will be almost certainly a pushback. It's a speculation, you never know how things will turn out, but this is quite likely. So this is at the level of international criminal law. Then, of course, at a deeper level, there's a whole debate about what exactly are human rights. This whole debate, it's not the topic for today, so I don't want to delve into it now, but that's also on the table again, I would say.
Maris, you want to say something on emerging powers?
Yeah, just about this question whether the rise of new powers will influence human rights prosecutions. And I think the answer is yes, and probably in ways that we're not going to predict, because political scientists are really bad at predicting anything. But nonetheless, I will try. Because China isn't the only rising power, and I think two very interesting ones are Brazil and India, which are both countries with serious human rights problems, but also with vibrant civil societies and very strong entrenched judiciaries. And they also have stronger tradition than some Western countries with recognizing economic and social rights. So we don't quite know in what direction the rise of new powers would actually influence human rights prosecutions. And I would say even for China, though it's difficult, I think, for us to see China in its foreign policy in the short term having a beneficial effect on human rights prosecutions, it is also the case that even China is not immune from this notion of the Justice Cascade, and I find it very anecdotally in Chinese students who are beginning to ask questions about their own past and whether transitional justice belongs to China or not.
Yeah, I just want to come back to this question of whether or not foreign trials are legal or not. And I think this takes us right into the zone of counterfactual analysis, which I have to say, in short response to your first comment, I don't think that much of what we're talking about is, a lot of what we're talking about is what's happened. It is not about counterfactual analysis, but the question of foreign trials and whether or not a lever in this case is definitely about counterfactual analysis. I could tell you a very likely story whereby if there was a foreign trial, rather than being a lever for spurring positive change, it might lead to very active mobilization on the part of the US government to revoke military aid, revoke military economic support, exclude the state that's pursuing a foreign trial from whatever international or regional organization it possibly can, and move things in a very different direction. There's nothing to suggest that it would necessarily be a lever. The other point about leverage is that it cuts off a national conversation about who, what, when, what should come under consideration, and you leave it to a foreign mechanism, an external mechanism, to make the choice about which person for which crimes, which I think is part of the problem of the ICC complementarity principle as it's evolving, right? It's not that the national conversation then opens up to consider who, what, when, how, and how do we deal with it. It's you have to deal with these people to this high of a standard for these crimes in this country, and I think it shuts down a more productive conversation that doesn't have to take place immediately.
First, unfortunately, there is no national conversation in the United States right now about accountability for the Bush administration. We just had an election, and I can tell you, it was not mentioned by anyone in the electoral campaign. So we have zero national conversation. This is a single time when one of the presidential candidates mentioned the issue of accountability. Nothing. So. So when you have a zero discussion, then it's not hard to provoke more than that. But second, Adele, of course there'll be backlash. So no one should be under the illusion that I'm saying this is going to be easy, what I'm proposing to you, okay? There will be terrible backlash. Just the way the United States punished Belgium for universal jurisdiction law, it will punish any efforts to have, there are countries that have independent judiciaries, and the Italians, Berlusconi managed to say, actually, we have an independent judiciary. And as I think you in the United States understand, what it means to have an independent judiciary is that we can't stop these guys. And I don't know what idea you have about how independent judiciaries function, but in our country, the executive actually can't stop the judiciary when it decides to do something. But under no illusions that there won't be terrible backlash. I agree.
I think there is a conversation. I don't think it's taking place amongst elected officials or those who are aiming to become elected officials. I think it's taking place amongst the Catherine Sittings of the world who are American citizens. I think it's taking place initiated by the David Coles of the world and the New York Review of Books and the ACLU and across a small but vibrant civil society. And I think it's a long-term game. I don't think it's a short-term game. And I think it's ultimately more productive.
Okay. Any other questions? I see two hands over there.
I guess I'm not trusted. First of all, thank thank you to everyone on the panel for all those interesting presentations. My question is for Professor Sikkink. In your PowerPoint and during your talk, you made the point that, or one of your conclusions, I think, was that prosecutions can have a positive impact even if they're partial, and that was the word that you used. Frankly, I found that statement a bit troubling, and so I wanted to follow up on that with you. In my mind, at least, perhaps my assumption is wrong, but if a trial is partial, that's code for unfair. And if you can clarify, please, how can a prosecution be positive if they are unfair to some people?
I'm sorry about that misunderstanding. What I meant by partial actually took it from America's Watch report in Argentina that was called partial justice. And what they meant by that was that not all perpetrators or suspected perpetrators will ever be prosecuted. So by partial, and many, at least in Latin America, many victims groups really want every single suspected perpetrator put on trial. And that, except in Chile where it actually may happen, it's not going to happen anywhere. And so some people are extremely disillusioned when they find only a handful of suspected perpetrators are going to be prosecuted. And what I mean by partial is even if only a handful, even in Guatemala, and Dan Saxon is here, has worked very much on Guatemala, even if in Guatemala we only get a conviction of Rios Montt for genocide, that would be partial justice, but it would have a huge impact.
Thank you. Then there was a question of the gentleman next to you, and then over there. But first, yeah.
Thank you, panel, for the masterclass this afternoon. It strikes me that in the presentations and the debates about international justice and more in particular ICC, there is a lot of attention for cases, of course. There is much attention for the defendants, the evil ones, probably. For the prosecutor, very much himself. This festival has shown two movies, one called The Prosecutor, and the other one might have been called The Prosecutor 2. And
that's just the beginning, yeah?
Okay, you promise. Now, what is, in my view, and of course about victims, and you look at the program today, what in my view is missing a little bit are the witnesses. I was glad to hear somebody say the trial needs the witnesses more than vice versa. And then I think Professor Dijs mentioned some victims will dare to be witnesses, but there are also witnesses who are no victims. And now Dr. Lindsay Murray mentioned the big guy, the powerful, the Banamukugwa, as they call him in Africa. You can imagine a witness with his family is unprepared, taken abroad, relocated to a safe country where they don't know how things work. Meanwhile, that powerful defendant, accused, will have found out that the person missing from his village for over a month or longer is probably a witness. So threats, harassment of relatives start.
Is there a question?
Yes, there is a question. This is very traumatic, and after a long process, the witness makes a statement, reconfirms, and then the names are disclosed to defense. Then the harassment increases, the threats increase in church services, in the media, and you mentioned the case of Kenya, where now the president-elect is a suspect here. So you can imagine these witnesses are scared to death. It's about their future, their families. Where will they go after the trial? Do they still stand to? Do they still dare to stand trial?
I think I've got your point.
And now the question is, what And they then would like to be assisted by a lawyer in their dealings with the ICC. There is no provision for this in the Rome Statute, as far as I understand. So these witnesses may fall victim, in fact, of this situation.
Okay, I've got another. One is witnesses, a special category of victims, a lot of issues involved there, and this gentleman saying more or less, in general, they're getting too little attention in all discussions about international justice. Can you say anything on that?
I think I quite agree with your point. I would first point out that there's at least three categories of witnesses: expert witnesses, insider witnesses, and I think both of those are also interesting and problematic categories. But for the victim witnesses, the problem goes way beyond Kenya. I think international criminal courts in particular are not very good at witness protection, and that's partly because they're not of that society, partly because of the financial issues engaged. And we know they sometimes become collateral damage of international criminal trials, and I can't say much more than that about it.
Thank you. I have one more question over there.
I would like to pick on from where a professor from the Free University Amsterdam spoke about politics influencing international law and jurisprudence. But I think the neoliberal framework also, I think, is influencing and exerting pressures, sometimes evident, sometimes not, on the whole legal framework. For instance, Nigeria would come to my mind, the problems and violations of human rights in the Niger Delta, or what's happening in Cambodia, where free run for the real estate developers is leading to a lot of violation. So how can you theorize and how can you stay silent without theorizing the pressure the neoliberal framework is exerting on the international law and therefore on the human rights criminal proceedings in general? Thank you. That's my question. I think the professor from the Free University could respond or anybody could. Thank you. Bye.
Actually, professors from the University of I think in Chile.
Sorry? Okay, well, thanks for the question. I'm afraid it's a bit to answer now to give a theoretical framework how to understand the impact of neoliberalism on international criminal law. But I will take your question, and I think it's a really important point, because it shows that in the first place it is important to take into account this broader political context to see the pursuit of international criminal justice as a form of legalistic politics, which is nothing to denounce it, but to understand its political role. Secondly, what is important is that international criminal law, of course, gives it a very particular way of framing what is at stake in political disputes, right? So the narrative is about who did what, who was the victim, who was the witness. So by definition, it is a very limited way of talking about political atrocities, political violence, political conflict, etc. So also for that reason, I think it is very important to import this, because otherwise you end up, and that was one of the points I'm trying to make, you end up with a very particular understanding of what global justice is about. But it's still only the answer to a theoretical framework, but I hope you will forgive me that I can't give you the whole theoretical framework.
Okay, we do that with theoretical framework. Okay, now one last question over there.
Yes, hello. I have a question that's asked by our students from Germany and Croatia. Last night we had the honor of meeting two of the Ugandan activists here in the foyer. They were activists in Uganda for the gay community. And the question to them was, one of them, was how much does pressure from the international community help the case of the gay community? And they gave an answer that was very interesting for us. They said that is very good, it is very important, but what they have to keep in mind is that it has to be subtle, it has to be nicely done, because otherwise all this pressure can backfire because of the pride of the nation. and then internally, like domestically, it will actually just get worse. So our question is, do you think that the balance between pride of the big countries, that they can take care of their own people, and the diplomatic pressure of the international community will be an obstacle for big countries to ever be a part of this Justice Cascade? Because at the moment, big countries like the USA or Russia and China are missing in these treaties. How do you think we could implement them, and how effective it is without them?
Yeah, I think it's a fabulous question. One of my colleagues, Estella, has been doing a lot of research on the LGBT mobilization, domestic advocacy in Uganda, and his story, I think there does seem to be that the local activism, which was early and very important, suffered the unfortunate and unintended consequences of the international advocacy community getting on the bandwagon without understanding that turned what was being done domestically into, it sort of discredited it because it became about gay rights being promoted by Western imperialist powers. And it made it very difficult for local activists to pursue their work as effectively. And I think it's a wonderful parallel, actually, to some of the politics. And it's not to say that this is right or wrong, but it's deeply political. And so, with the best will in the world, unfortunately, often, once it comes from the international, it's very easy for positive pressure to be mobilized in such a way that it picks up on local discourses that have a long historical trajectory and moves people away from support for international justice. So I think it's something that one has to be very careful about. And in terms of, what does that mean for the sort of great powers engaging and investing? I think it means, I guess in all of this I'm sort of saying give more time for local debate and local advocacy, and the role of the international court and the international architecture of justice, as it were, as a sort of shadow and as a light footprint is important, but in terms of active intervention, I think it's deeply problematic often.
Okay. Thank you very much. So last chance for all four of you to answer questions that were not posed. Anything you want to tell us? As kind of last remarks. Yeah? Marlies, sorry.
Okay.
I didn't actually, in my speech, answer the question of the debate, are human rights prosecutions really changing world politics, so I thought I'd do it now. And my answer would actually be they already have. And I think to some extent the question that Leslie asks about whether it wouldn't be more helpful for peace negotiators to be able to put amnesty on the table is already historic and irrelevant. Because even if they could put it on the table temporarily, what I take away from the Charles Taylor situation or the Rio Montt case is that amnesty can never be unconditional. Perpetrators will forever now have to look over their shoulder. Now, that could have preventive effects for potential perpetrators. It could have hardening effects on people already responsible for crimes. But I think that shadow that you just mentioned, that's a permanent shadow now. But it doesn't just enable human rights activists to constrain potential perpetrators. It enables and constrains political actors in all sorts of new ways that we're still beginning to discover.
Okay, thank you. Catherine?
Well, I would say two things. One, I'd say it's important sometimes to step back and take a long-term perspective. And I know that when we're very involved in a particular case, in a tribunal, in a particular conflict, where things seem very dire, okay? And it's easy to think that we've gotten it very wrong, we have to change everything. And what I found by stepping back and taking a bit of a long-term perspective is that it helps you see that there are like for example, international pressure almost always provokes backlash and denial. This is the point that Thomas Rees and I made in our book. But it would be good if pressure were subtle. It often is not. And over time, for example, it was not subtle at all to arrest Pinochet in London. Chile went wild. People said, of course Chilean democracy will end, right? Because the British have been so unsubtle in their... In the end, as we look back 15 years later, we realize it was a crucial turning point for justice in Chile. Okay, so that even if the International is unable to be subtle in the long term, but ultimately, change, and here I think Leslie and I agree completely, change must begin and be sustained primarily by domestic actors. If you don't have domestic actors who care about change, you're not going to be able to bring it about. International actors mainly work to help protect and open space and sustain and support domestic actors. So I think it's important for them to see the role of the International in that way, of opening up space so that domestic actors can demand and succeed in their own change.
Thank you very much, Moniz. Leslie, Catherine, thank you very much for your introductions with contributions to this panel. I think it was a great debate.